Hi, this is civil rights staff attorney, Stephen Wheeler. I'll be talking specifically about our housing work. I do some other work, including employment, places of public accommodation, and access to vocational rehabilitation services. And you have some background on that through other updates. But because you have seen that through other updates, I'll be specifically talking about our housing work. Uh, for PAIMI housing work, we focus on discrimination issues. So that can be a range of refusal to provide reasonable accommodations, refusal to provide reasonable modifications, and a refusal to provide housing, either through a denial of an application or through a discriminatory non-renewal. And that's where the denial of an application or the non-renewal would be specifically because of the person's disability, in this case, mental health disabilities. We've had some good success recently on a housing case that we've been working on for just over a year now. And in that situation, a person with major depressive disorder, major depression, and an anxiety disorder with panic attacks was trying to get housing that included a reasonable accommodation to allow her emotional support animal. The landlord had refused to provide accommodation because they didn't like the medical documentation that she provided. It met requirements under federal law, but didn't quite meet the requirements to get protections under state law. Where there's a difference in those laws, the stricter of the two applies. Both apply, but it ends up meaning that the stricter of the two is what the landlord would have to follow. And the landlord was not following in federal law in that situation. So I stepped in and we were able to quickly get the landlord to change positions on accommodating the specific individual and providing, allowing her to move in with her emotional support animal. What did take much longer, and that we're recently made a good milestone on, was trying to address the systemic issue from that specific landlord. It wasn't a matter of an individual leasing agent messing up and failing to follow the organization's policies. In this particular case, it was actually that the organization had a policy of denying accommodations when the medical documentation, even if it met the federal standard, if it happened not to also meet the state standard. This organization, this landlord, was denying accommodations in those situations. So we had been pursuing a resolution to try to get the systemic piece for this landlord resolved. And just in May, they did agree to a settlement agreement that included revisions to their policy, communication with their staff to make sure that the staff follow the compliant policy instead of the old policy. And also, I think very importantly, the landlord agreed to put us in touch with members of a local professional association for landlords that they're active in, which is where they had initially gained the misunderstanding about the interaction between federal and state law. They had been confused by some information presented through a professional association. And so they agreed as part of the settlement agreement to cooperate with our efforts to reach out to other landlords in that association to prevent the error that they made from being repeated through other people who received misinformation from the same source that they did. So I think we made an important stride, not just for the individual accommodation, but also in obtaining a settlement agreement that allows us to go upstream and try to resolve it for other large landlords in the area. So that's I think an interesting and recent specific piece of progress. And then as background for folks watching the video who would just like to know more about what we do in mental health and housing, it's not, even though emotional support animals and service animals are an important piece and an area of question and requests that we get a lot of, there are other ways that reasonable accommodations can apply in housing for people with mental health conditions. So for example, a while back, we had someone who needed personal care assistance to come help her because of functioning, where portions of the issues were based on her mental health. And she lived in a location where the landlord actually had restrictions against having guests on the property. And based on those restrictions, she was being charged fees whenever her caretakers would come onto the property. And the landlord had initially refused to grant an exception to that, to that guest fee policy. We were able to help her obtain an exception, a reasonable accommodation, to have her care workers able to come onto the property without being treated as guests for purposes of the landlord's guest restriction. So that's some of what we've been doing in housing, and it's always good to talk to this group. Take care.